Good morning, everyone, and welcome to our next session. And we have quite an interesting lineup for you today. We believe you'll find it of interest, and thanks again for taking time out of your busy diaries. We know it's quite hectic out there in the insurance industry at the moment. But I think today, I just want to welcome Lee and Chris from Clyde Co. They'll be addressing us on certain specific issues surrounding cyber, including the regulatory environment. And then also, I think, very interesting for everyone would be some of the case studies that they'll be discussing with us. They'll also give us some practical tips, so I think, stuff like that is quite important, especially to assist yourselves in guiding your individual clients, in one of these sad events that is no longer, out there. It's a material risk, and we expect to see more action on this area. After Lee and Chris, I'll be handing over to Pierre and Colin. They'll be dealing and delving into the actual differences between your computer crime section of the crime and civil liability and certain commercial crime policies versus a cyber policy. We have seen in the past that certain people would just assume that, because they have computer crime, they have cover for everything else, anything to do with cyber, which is obviously not the case. So hopefully that'll also be some practical information that you can utilize in your day-to-day operations when it comes to cyber. I think, just some of the other issues, please, if anyone has any questions, please just put it in the question box at the bottom of the screen. But without any further ado, I think, Lee, you up first. Please will you entertain us and share your insights. Thanks a lot.
Thanks very much, Anton, and good morning to everyone on the call today. And thank you to SHA for allowing myself and my colleague, Chris Mcroberts, to speak to you. We're going to spend the next sort of half an hour or so taking you through a closer look at cyber claims. We're going to set out some of the claims that we've dealt with. We're going to unpack some of the issues that have arisen from those claims, and hopefully just to give you some insight into what actually happens on the ground when dealing with cyber breaches. As Anton mentioned, I believe there is a chat room where you can raise questions, and if we have enough time at the end of today's session, we'll attempt to address those, or we can do so after the presentation itself. So in terms of the agenda from Chris and my side, I'm going to just spend a few minutes sort of setting the scene in terms of the legal and regulatory environment that we currently find ourselves in, obviously with particular emphasis on POPIA and certain of the provisions within that act. We are then going to turn our attention to lessons from the front line, and Chris and I will take you through a few case studies, and as I've mentioned, discuss some of the interesting things that we have learned arising out of those cyber breaches. We'll then speak to you this morning about some cyber resilience do's and don'ts. And then lastly, we're going to gaze into the crystal ball, look ahead and try predict some of the cyber trends that we think may be on the horizon. Now, in that regard, we of course live in very interesting times at the moment with the Ukraine-Russian incident that we're all monitoring carefully. And of course, a very significant part of that conflict is cyber warfare. So Chris and myself and my colleagues at the Clyde Co cyber team globally, with colleagues based in Australia, the US and Europe, we're monitoring that very carefully as a situation, because of course there might well be a knock-on effect from that incident around the world. And it's going to be very, very interesting to see what what comes up in the next few months. So that's the agenda for today. So if we can just go back to some basics and set the scene, I think it's important to always bear in mind when we look at cyber incidents to remember that Section 14 of our Constitution provides that every citizen of South Africa has a right to privacy. And POPIA, when it was implemented as a piece of legislation, gives effect to this constitutional right to privacy by safeguarding personal information that is processed by a responsible party. And the way in which POPIA does this is, firstly, it regulates the manner in which personal information may be processed. And secondly, and very importantly, it provides individuals with rights and remedies to protect their personal information. So essentially, what POPIA represents is global best practice in terms of how personal information must be processed. If you as a responsible party are complying with the conditions set out in POPIA, then you are complying with what is generally considered to be best practice for the processing of personal information. In terms of POPIA, and I'm sure there are many of you on the call today that have probably heard us speak about this before, but it's so important in the context of the environment that we face and the cyber claims that we're seeing, that we take note of the liabilities, the damages, and the fines that can arise out of the provisions of POPIA. And we've highlighted, or we wish to highlight, a few of those sections for you today before we dive into the cyber claims scenarios that we will speak about. The first section that stands out is section 99(1) of POPIA, which provides strict liability for civil claims by data subjects. What that means in plain terms is that data subjects can institute proceedings against responsible parties for non-compliance or breaches of the Act, irrespective of whether there has been intention or negligence on the part of the responsible party. Now, that's important from a legal perspective because it sets a fairly low threshold that the claimant has to overcome in order to prove his or her claim in law. And we anticipate that that section and that relatively low threshold that is set will encourage data subjects to ultimately pursue claims against responsible parties. Related to that, under section 99(3), is the fact that our courts are afforded a discretion to award such data subjects compensation in the form of just and equitable damages, including aggravated damages. Now, as we sit here today, we do not know, or we have no authority within the context of POPIA, how our courts will interpret just and equitable damages and how our courts will interpret aggravated damages. But the wording of the Act itself, as you can see, suggests the strong possibility of fairly significant damages that could be awarded by our courts in appropriate circumstances, and it could include damages of a punitive nature in the form of aggravated damages. So section 99 and subsections 1 and 3 really do represent very significant provisions that may well see scrutiny by our courts in due course. Then, as many of you know, the Act itself also provides under Section 109 for administrative fines that can be imposed by the information regulator of up to 10 million rand. In imposing such fines, the information regulator is entitled to consider various factors when determining an appropriate fine. And we've highlighted one of those factors for you today because of its importance in our mind. And that is the fact that the information regulator can consider any failure by the responsible party to carry out a risk assessment or a failure to operate good policies, procedures, and practices to protect personal information. Now, if we just pause there for a minute, we know that the board of directors of a company are tasked with the responsibility to ensure that the company complies with the laws and regulations that apply to it. And that would naturally extend to the provisions of POPIA. In the event that the company, being the responsible party, faces civil claims under Section 99, or possibly administrative fines under Section 109, it is quite foreseeable that the knock-on effect of that liability, regulatory or civil, if established, will be the fact that scrutiny might then turn to the individual directors and officers of the companies, particularly within this responsibility that they carry to ensure that there are appropriate risk assessments and appropriate policies and procedures in place. And the reason why we wanted to flag that for you today is because when you sell or when you sell cyber policies and you speak to your clients about cyber policies, it's important as well to emphasize the fact that it's not just the company that might be in the firing line. It could also be the individual directors and officers of the company. So it has a liability perspective that would be well addressed in the form of a D&O policy. Of course, we have to mention the developments that we've seen in the last sort of fortnight with the information regulator in the context of the TransUnion cyber breach. I'm sure we've all been watching with interest the press publication and reports surrounding the breach that TransUnion has suffered. And what's interesting about this, just as a general sort of observation, is that it seems to suggest that we're moving towards a more proactive information regulator. The Business Day headline last week on Friday, the 25th of March, stated as follows: TransUnion ordered to advertise compromised information. It went on to say, SA's information regulator is unhappy with the Credit Bureau's response to the hack by NaughtySec TU. TransUnion said in a statement on Friday that at least 3 million consumers were affected by the hack. It has started messaging and emailing those affected. This is a very significant development in our minds because it shows that the regulator is starting to flex its muscles, we think, in terms of cyber breaches. And it seems to be a move towards a more active role that our regulator is playing. And it's going to be very interesting to see in the next few weeks how this particular incident plays out, both in the perspective of how TransUnion deals with this, this breach, how TransUnion deals with the regulator's engagement with it, and how the regulator itself handles the breach going forward. Just concluding then, in terms of TransUnion, one final observation is that it seems to us that this is the first time that publicly the regulator has taken an approach and exercised one of its powers afforded to it under Section 22, subsection 6 of POPIA. And that particular section provides that the regulator may direct a responsible party to publicize in a manner specified the fact of any compromise to the integrity or confidentiality of personal information, if the regulator has reasonable grounds to believe that such publicity would protect a data subject who may be affected by the compromise. So as I say, we are seeing in real time the regulator start to apply the provisions of the Act. And if you think about those liability provisions and the like, it may be the case in time within the context of what we've seen at the moment, or new incidents as and when they arise, that the regulator may proceed to apply these powers afforded to it in respect of cyber incidents. So, concluding with our snapshot of the regulatory environment, one must not forget, of course, that the Cybercrimes Act 19 of 2020 has also been passed by our legislator, and certain provisions, not all the provisions of that act, are currently in force. The act itself, in terms of its objectives, is to create offences and impose penalties in respect of cybercrimes, to criminalize the creation and distribution of harmful data messages, and to provide for interim protection orders and to further regulate jurisdictions. The Act also includes obligations, reporting obligations, although these are not yet in force, for electronic communication service providers and financial institutions to report on cybercrime. And failure to comply with those reporting obligations may give rise to fines not exceeding 50,000 Rand. So again, in conclusion, what we are seeing here is a regulatory environment within which companies and the board of directors must operate, and regulations that they must comply with, which are becoming increasingly complex. And in concluding, in terms of the regulatory environment within which your insureds and your clients are operating, bear in mind that it's not just POPIA, it's not just the Cybercrimes Act that will apply, but depending upon the industry within which your client operates, there may be additional pieces of legislation that will also contain reporting obligations and the like that your insureds will have to meet. The obvious example being the financial services industry and financial services legislation that provides for additional reporting obligations. So again, it's a complex world, it's a complex environment, and companies and directors need to be extremely mindful of these regulations and the legislation. Turning then to the front line and the case studies that we want to discuss this morning, I think just as a general starting point, we have seen a significant increase in cyber claims in the past 12 months. And in fact, in the past month or so, we've seen an explosion of claims. And just two trends to pull out of that. The first is that these claims have struck across a broad range of industries, financial services, transport and logistics, healthcare, and the professional services environment. The second trend to note is that these breaches can involve all manner of companies, SMEs, medium-sized companies, and large corporates and listed entities. So what is apparent is that cyber claims are indiscriminate. It doesn't matter who you are, it doesn't matter what industry you are operating in, it seems to be the case that everyone is a target. And again, we think it's worth emphasizing that at the point of sale, when you speak to your clients about cyber claims, is that the trends that we have seen strongly point to the fact that the target company can literally be anyone in today's world. So, against that high-level backdrop, let's turn to our case studies. I'm going to conclude my part of the seminar this morning and speak to you about one case study, and Chris will then take over and speak to you about a couple of others. These are real claims scenarios. We have naturally anonymized them to protect confidentiality and adjusted them slightly, but the substance is taken from claims that we have actually seen and issues that have been dealt with in a day-to-day basis. In terms of case study one, Salus Warehousing and Transport. Salus is a national warehousing and logistics company. It provides a range of services to customers across Southern Africa. What happened in this particular incident is that during a routine data transfer from a service provider, i.e. an external party, a corrupted file was transmitted into the insured's own IT environment. When the corrupted file was accessed, a malware variant known as Anton was executed and encrypted various servers and systems. Unfortunately, before the insured's environment could be fully shut down, the threat actors had managed to exfiltrate company-sensitive and customer information. What this breach illustrated, and the point that we want to just emphasize in the context of this case study today, is the significant downstream impact or knock-on effect that an extensive malware attack can have on an insured company. So in terms of that downstream effect, what this particular incident showed in terms of its unique features was generally three different things that arose from it. The first, interestingly, was the fact that the data exfiltration of the target company led to a further ransomware attack launched on a subsidiary to the insured. And the subsidiary's data was also encrypted, and threats were made that the stolen data would be published if the ransom demand had not been met. So again, it's illustrative of the fact that when you're speaking to your clients and they are part of a group of companies, an attack on one company, the target company within that group, can of course have a knock-on effect in terms of broader subsidiaries of the insured. The second aspect that emerged from the Salus breach scenario was the fact that the malware itself caused significant business interruption related losses, not just for the target company itself, but also for its subsidiary. And I want to just pause and just unpack that for a minute, because what has emerged from these cyber incidents is the devastating impact that they can have on a company's operations, particularly in the first 72 hours and the first 7 days of an incident. It is not an overstatement to say that the company's operations can be stopped completely in certain cyber incidents. And the company's entire resources, staff, senior executives, cyber and IT departments, PR people, the legal teams, their entire efforts have to be focused on ensuring that the threat actors are no longer within the environment and that the company's information and data is now secure, and within that, an assessment has to be made as to what data has been potentially compromised, accessed, and or acquired by the threat actors. So the business interruption loss is a significant one, and it can go on for a number of days before the company itself is able to get up and running again. And if you just think about that in the context of an SME, that can naturally, and medium and large size companies, it can have a significant and potentially devastating effect on the company itself. The third feature that emerged from Salus, which we want to just highlight for you in the context of this case study, was the fact that the company's customer agreements contained some rather onerous non-disclosure and confidentiality clauses and reporting obligations. And the importance of this aspect is that it must be borne in mind that when there is a cyber incident, it is not just the reporting obligations under POPIA and other legislation that you need to keep your eye on. It is also the potential contractual obligations to report to your customers, your clients, and your suppliers that you need to monitor. And what's interesting about that is that these contractual obligations can often be more onerous than the regulatory obligations. And just to illustrate that point, Section 22 of POPIA provides that you have to notify data subjects and you have to notify the information regulator after the discovery of a compromise. And I want to just read the particular provision here from the Act. Taking into account the legitimate needs of law enforcement or any measures reasonably necessary to determine the scope of the compromise and to restore the integrity of the responsible party's information system. So what Section 22 does is that it does provide your clients with some breathing space within POPIA to report to the regulator once they have taken control of their environment. That might not necessarily be the case in a contractual setting, and one would have to keep your eye on it. And it was something that emerged within the Salus case study. So then, in conclusion, in terms of how this particular incident resolved itself, an incident response manager and cyber forensic experts were appointed to assist Salus and to determine how the malware affected the insured systems. A vulnerability within the insured service provider was discovered and fortunately was remedied. Salus was fortunate. It had a cyber policy that was able to cover the costs of resolving the cyber incident, importantly for both the insured and its subsidiary company that was drawn into the cyber breach. In this case, the insured refused to pay the ransom demand to the threat actors, and the insured's encrypted services, fortunately for them, were restored from recent backups. And of course, backups, we know from a risk management perspective, regular backups is crucial. So Salus was interesting, as I say, for a number of reasons. In conclusion, it is that knock-on effect that these sorts of cyber incidents can have. We're going to turn now to the next couple of case studies. And at this stage, I'm going to turn over to my colleague, who I know many of you know very well, Chris Mcroberts, who will take us to the conclusion of our presentation.
Thanks very much, Lee, and good morning to you all. I'm going to talk to you about a couple more real-life case examples that we've seen and how those were resolved. And I'll then talk to you about some general trends, some do's and don'ts, and a sort of looking ahead into the cyber market and what we foresee happening with claims. So turning to our second case study, the entity here is a company called Veneer Tech, and it deals with the importance of multi-factor authentication. That may be a term that's familiar to you if you've been through a recent cyber renewal or had to look at any recent cyber proposal documents. MFA is a hot term in terms of security protocols. And for those who may not know what that is, multi-factor authentication is where you need to use a second method or device to validate access on an initial device. So for those of you with internet banking will be familiar with the concept of a one-time PIN. That is a good example of multi-factor authentication, where you validate your authority as a user by entering an authentication method that is unique to you and which is secure. So Veneer Tech is a payment authorization service provider. What happened in this case is that one of its employees clicked on a phishing link while on a music streaming website. That link took the employee to a Microsoft landing page where he input his Microsoft account details. Now, we say it's a Microsoft landing page, but you will probably guess that that is not really the case. So what we're talking about here is a spoofing attack where there's a two-pronged methodology. The first is a phishing email or a phishing link, which has been generated, and that then takes the user to a website which purports to be a real, a legitimate Microsoft website. The account details are then entered, and those can then be used to compromise that user's account, and by extension, the company for which he works. So the threat actor, once it had those credentials, ran a harvesting tool known as Mimikatz, which we frequently see in these events, to obtain administrator privileges on the insured system. And it acquired 4 terabytes of data, which it then proceeded to encrypt after it had taken that data out. So there was an access problem, there was data exfiltration, all of which came through that initial entry point. The trouble here is that no multi-factor authentication was implemented on the system, which allowed the threat actors to access the insured's IT environment undetected. So the importance of multi-factor authentication on this example is that had that been enabled, there would have been a message sent to the user to indicate that there was a login on their account. And with the knowledge that that wasn't legitimate, they could have then alerted their IT team to that, and it could have been stopped at an earlier stage. What was the impact of this incident on Veneer Tech? Well, it had to undertake notification to data subjects and to the information regulator, given the reporting obligations which Lee has described in section 22 of POPIA. The lack of basic cybersecurity of this insured was a concern for the insurer. And this is an important example because it deals with the classic issue of disclosure in insurance, and specifically disclosure of security protocols on cyber policies, which is probably the biggest coverage issue that we encounter on cyber claims. So given those concerns, the insurer instructed coverage counsel to look at the implications of the inadequate cybersecurity, and also whether this would trigger D&O coverage if a claim was made against its information officer for a breach of POPIA. So this again shows the secondary impacts of a cyber claim, that you can have D&O exposures against individuals in the company based on inadequate security safeguards as a potential source of liability. And by extension, coverage counsel also had to look at section 99, which Lee discussed earlier, relating to strict liability under POPIA. How was this incident resolved? Well, MFA was only going to be made mandatory at the next renewal. So fortunately for the insured, the policy would respond despite there being no MFA in place. So it wasn't a fatal coverage issue on this claim. Fortunately, the incident had a fairly minimal impact to the operations of Veneer Tech, and its IT service provider was able to work with the insurer's appointed third-party specialists to implement MFA. This is something that we often see in cyber claims, that as one starts picking through the weeds on a claim, you identify weaknesses that need to be addressed and gaps that need to be closed. and obviously implementing MFA was a no-brainer given what happened here. Coverage Council was asked to look at betterment in its advice to insurers. This is a great example of betterment in the context of a cyber claim, because what we have here is an improvement to the insured's environment which needed to take place because of a claim, which does give rise to an element of betterment. The insured made the necessary notifications to data subjects and to the information regulator, and we were able to provide guidance on that. And fortunately, once those notifications had been made, there was no response received from any of the affected data subjects or the regulator. And happily for the insured, there was no claim against it or its information officer. So although we were able to give that precautionary advice to look at the liability exposures, those didn't materialize. As Lee said, the regulator is starting to flex its enforcement muscles, so that may not always be the case. What learnings did we and the insured take away from this case? Well, the importance of multi-factor authentication is demonstrative of a global shift towards tougher cyber insurance onboarding. Those of you who are brokers, I'm sure, will be very aware of this, that the underwriting process for cyber is onerous, the questionnaires are long, there is a lot of technical analysis which now takes place, and that's a feature of a global shift in the cyber market. It means that businesses have to prioritize their IT security posture and adapt more quickly to global best practice. One of the challenges we have with this in South Africa is that there are no prescribed minimum standards for cybersecurity in terms of ISO standards or other equivalents. So it is sort of left up to insureds to determine their own level of cybersecurity. When we're dealing with multinational companies, that's usually not so much of an issue, but for SMEs and smaller local companies, it can be a challenge. And what all of this means is that cybersecurity is getting closer to the boardroom. And we think it's only a matter of time before a failure to implement basic cybersecurity protocols will result in D&O claims. It is a source of liability. It is happening elsewhere. And like many things in other insurance markets, it's only a matter of time before we see it in South Africa. This also chimes with the trend of cyber insurers looking more to their insureds to take responsibility for their own security environment and to participate closely in the risk. And you will see that with the way that limits and excesses are being applied on cyber renewals at the moment, that insurers are looking to their clients to participate more closely and often to a greater financial extent in these risks. All right, and we're going to finish up with a third case study, which highlights the benefit of an effective incident response manager in terms of a cyber policy and the collaboration between service providers. The company in this claim was called Vulcan Engineering. It suffered a ransomware attack, which resulted in its servers being encrypted by an unknown party using a ransomware variant called Lockbit 2.0. We often find that these ransomware variants have strange and exotic names. The IT team immediately followed their incident response playbook and notified the head of legal within Vulcan Engineering, who in turn notified insurers in terms of the cyber policy that was kept in hard copy form. And we'll explain the significance of that in just a moment. The insurer proceeded to appoint an incident response manager, which was Clyde Co, and we had previously conducted what we call a meet the breach coach session with Vulcan to discuss its cyber incident readiness procedures. So fortunately, we weren't dropped into a situation where we didn't know each other. We had discussed the cyber playbook with Vulcan, and they had some idea of how it would work in terms of the insurer's response team, which was a very useful decision when the claim came a couple of months later. The impact on the business was that the encrypted server could not be accessed, which was a significant disruption to its manufacturing operations. Fortunately, the insured could work with the appointed cyber forensic experts to deploy software. In this case, it was called Cyber Reason, to uncover the vulnerability in the system and contain the ransomware. So that quick action meant that the toxic spread of the malware could be addressed quite quickly. What was interesting about the resolution of this incident is it was one of those rare situations in an insurance claim where everything just kind of clicked, and we had a great relationship with the broker who was pivotal in managing expectations between the insured and the incident response manager, and playing that crucial role of communicating and providing feedback and giving comfort to the insured. All of the costs, remarkably, were contained within the 72-hour emergency response period. We don't often see that, but because the insured was so well prepared, it meant that all of the triage, the upfront costs were contained, and the benefit to them was clear in that they then didn't have to pay anything out of their excess. It was all picked up in the initial response phase. Those costs were submitted timeously to the insurer and accepted, which was great news for the insured. And the learnings that we took away from this were the importance of that meet the breach coach session to familiarize the insured with the processes and with how the insurer's response team would work. And it meant that when the incident came, there was a quick response to the incident. Everyone was comfortable with each other, and the costs were handled very effectively. So the takeaway for any of you who are brokers is that it is worthwhile for those policyholders who haven't met the response teams to set up these sessions. We're very happy to participate in these Meet the Breach Coach sessions. We can talk through what the insured's response plan is or looks like, and we can give them tips about how that can be developed in anticipation of an incident. It's a little bit like running a fire drill for a cyber claim. It is worthwhile. It may seem like a chore at the time, but it can result in massive savings, both in time and impact when the claim comes along. All right, I'm going to march on to some cyber resilience do's and don'ts. I think these all come out of the examples, so I'm going to move through them fairly briskly. The first do, as I've just said, is if you can get to know the incident response team before an incident happens, consider a Meet the Breach Coach session. It's a good idea. Do run breach scenarios that can test an organization's readiness. From time to time, we've assisted insureds to put together fully fledged breach scenarios together with cyber forensic specialists, and we basically do a dry run for what a claim can look like. And in the most sophisticated examples of that, the ExCo and the board have not been told that this will be happening. It runs as a live simulation, and there's real benefit to that. It is important to ensure that organizational backups are regularly actioned and preferably staged and stored in a separate server environment. Reason for that is if malware runs through a server and can contaminate the backups, then you're unable to restore from there. So that separate staging is technically very important. And then we always speak about communication in the initial phase of a cyber incident. Have strong communication channels between your cybersecurity and SOC teams within an organization and management, and know who does what. Because what can be the most dangerous thing in the initial phase of an incident is if there are too many cooks and an overlap of responsibilities. Don'ts. Don't make your cyber policy generally accessible so that the hackers can find it. This goes back to the point I made in the earlier example of keeping a hard copy in a secure place. What we see increasingly in ransomware attacks is that hackers actually look within the insured's IT environment for a cyber policy, because they can then use that to apply leverage to negotiations if they're aware of the policy limits. And that is best avoided by the good old-fashioned method of printing it out and keeping it in a safe place. Or if it is going to be kept in an IT environment, making sure that there is heightened security and password protection on the policy so that it can't easily be accessed. Crucially, we always tell policyholders and brokers that they should not try to engage or negotiate with threat actors without looking for external assistance. Cyber claims almost always go bad in ransom situations where there is a measure of negotiation, and unfortunately we do see from time to time that IT people will initiate a negotiation process because they think they can get ahead of an issue, which only tends to make it worse. Ransom negotiation is difficult because there is a time element to it. There is an escalation in order to apply maximum pressure to the insured. And like any negotiation in the movies with hostages and ransoms and so on, you don't want to do it without a specialist assistance. Don't wait until after a cyber incident to implement risk improvement recommendations. I'm sure that SHA will agree wholeheartedly with that, but we want to see the best possible security protocols in place before an incident happens. And then most importantly, when it comes to an incident, don't create panic. Cyber incidents are extremely stressful in themselves, and it's important to work systematically through an incident to get on top of it, because whilst there are many internal and external pressures, panicking only tends to make things worse. So what are the cyber trends that we see ahead of us, and what's going on globally that may impact on the South African cyber market? Well, we're certainly already seeing more sophisticated, large-scale cyber attacks. And if you look at the Log4j incident, which happened towards the end of last year, which was a day zero vulnerability that was exploited, and then the SolarWinds hack, which affected software used by government departments across the United States, we can see the impact of those wide-scale incidents, which have the potential to run around the world even faster than COVID. We've already spoken about the hardening cyber market, that underwriters are tightening up their assessment procedures to manage potentially catastrophic risks. They are looking carefully at those large-scale cyber exposures, and they are looking carefully at limits and participation with their insureds to spread that risk around. As Lee mentioned earlier, in the context of Russia and Ukraine, we have been looking closely at cyber warfare and the exclusions that may be contained in cyber policies relating to that. There is a lot of an expectation that the escalating conflict between Russia and Ukraine will see knock-on cyber attacks. There's already precedent for that in 2017 with the NotPetya attack, which was launched by Russia against Ukrainian state targets. It had a significant spillover into companies like Maersk Shipping and WPP, the brand agency, which suffered substantial losses because of that incident, and we expect to see more of the same given the current situation. And then lastly, cybersecurity as an ESG issue. Anyone who's dealing in financial lines will know that ESG is on everyone's lips. Companies and regulators are looking at complementary risk management strategies to their insurance policies, and cybersecurity is something that comes into that mix. That brings us to the end of this section. I believe we're going to take questions at the end. There are a couple in the Q&A, but at this point, I'm going to hand back to the SHA team, and Colin, I think you'll pick up. So thanks very much.
Thanks, Christopher and Lee, for that very insightful talk. I'm just going to share my screen and get the slideshow running. All right. If that talk from Lee and Christopher didn't give you nightmares, then you haven't been paying attention. But the cybercrime is a really real threat and is affecting and could potentially affect everybody this day and age. Everyone's working on computers, everyone has internet pages that they use, and it's a very real threat that we need to consider. So just out of interest, something that you can look on Google to show your clients while you're discussing with them is the live cyber threat map, which is very interesting for people to have a look at, because it sort of breaks down all the incidents that are happening on a daily basis. You can see this was a screenshot from yesterday afternoon, and there are various millions of attacks happening every day across the world. There's different malware and phishing, as well as exploits that are happening. And this is just a great website to show your clients what is happening in the market and around the world. So if we're looking at insurance for these incidents, there's various possibilities, different options in the market. And you'll see on the financial line side, there's cyber insurance policies, and there's also the crime and civil liability policy, which does have parts of it that deal with cyber crime. You can see that the cyber insurance policy is different and broader than what is offered in the crime and civil liability policies. So that's something that brokers must take into account when advising their clients. Specifically, if you think that the crime and civil liability cover is everything that your clients are going to need. On a quick view highlighting the differences between the two, you'll see that cyber insurance policies cover first-party and third-party losses, whereas the crime and civil liability policy is more geared to first-party direct financial losses suffered by the insured. The cyber insurance policies looks at losses and expenses as well as defense costs incurred as the result of a cyber incident. And these policies are geared to broadly cover and remedy all losses suffered by the insured, as well as third parties' costs incurred. Whereas the crime and civil liability policy, it doesn't assist with costs incurred to fix a cyber incident. And there's generally no cover for third party claims unless it arises from a professional service. Pierre will be getting into more detail on the crime and civil liability side and some possible overlaps of the two policies, while we look at the cyber insurance policies and the cover that it offers in general. And you'll note that these points were discussed in detail by Christopher and Lee, and this is how the policies have been designed in the market to try and cover all aspects that would affect the insured in the event of a cyber attack or hack. So you've got, broadly speaking, you've got your first party cover and you've got your third party cover under the cyber policies. So your first party cover is looking at data breach response. So most importantly of all is your costs of an expert to come in and investigate the situation. So this is always your starting point when there's been a cyber breach in your system, is to get the experts in to see what it has affected on your system, how it's going to implicate you operating your business, and what the implications are. Are there data, subjects, information that has been obtained, or has your systems been stopped, is it no longer running? And that's why the experts are called in to investigate the situation and get a report of what the best process is to fix the current situation. This will also look at your cost to comply with your data protection laws, such as POPIA. And this is becoming more prevalent as the hacks are becoming more active in our country, and it does seem that the POPIA Act is being enforced more stringently at the moment. Then you've got your costs of credit and identity theft monitoring services. So this is particularly in the case where, for example, the TransUnion matter that's in the news, where you have a lot of personal information from data subjects that has been accessed and released to the market or used for nefarious reasons. And that data is often used to create identity theft of people or to make credit applications on their name. And this is a service to monitor those data subjects that have been affected in the cyber breach, and to make sure that they are not having their personal information used for identity theft purposes and credit applications. So this is a very important aspect that one needs to consider. There's reputation protection expenses. So specifically for the bigger corporate insureds in the market that have a media presence, and there's news stories about them and this hack and the implications. This is to get a PR firm involved to try and counter the negative publicity that they're receiving in the market. Then it also covers the defense cost aspect. And the defense cost aspects, as Lee was mentioning, can result from the POPIA Act, where data subjects are either instituting action against you for the loss of their data, as well as action that is instituted by the POPIA itself, and fines and penalties. So that's also included in the cover, is the legally insurable administrative fines and penalties, which may result directly out of a cyber hack or breach on your computer system. Then there's two aspects, restoration and business interruption, that link closely together. So as a result of a cyber hack, be it ransomware or any other kind of hack that has occurred, the first problem that the insured is going to encounter is that business interruption. So their system may be down and they may not be able to participate in the market anymore, which results in a loss in their net profit. And during this interruption period, you have the restoration process that is taking place, and the policy will cover the costs involved of getting the data and software of the affected insured back up and running. So these are two very important aspects that insureds need to consider in their policy response. Then you have cyber extortion, and this is the reimbursement for ransom. If there is a ransomware attack and it has been, after expert advice has been provided and the matter has been investigated, and this is probably decided as the best solution going forward, then the policy may respond to reimbursement for the ransom to get the insured's data released and unblocked so that they can continue their business running. Then you have a cyber crime aspect to the policies, and we find that this isn't in all the cyber insurance policies out there, and brokers will need to consider this when advising on a particular policy, because the cyber crime section specifically covers the theft of money from the insured as a result of the third party's cyber hack into their systems. So this could be an instance where, as a result of the hack, the hackers are able to get into the insured's banking system. If they have an online banking system and their passwords have been compromised and money is stolen from their bank accounts, this is a very important part of the policy to make sure that there's cover for that direct financial loss that the insured has suffered. So moving on, we'll look at the third party cover that cyber policies would cover, and that's liability to third parties following a data breach. So this is a data breach on their own systems, and this has caused a liability to third parties. So either they've instituted action against the insured because the breach has allowed interference on their computer systems, which has caused third party loss. So this might result in civil litigation being brought against the insured. And this third party is designed to cover those litigation that may result due to these breaches. There's also instances where a cyber breach has occurred, and without the insured's knowledge, their systems are being used in a malicious way, to attack third parties' computers, either by a data breach or theft or denial of service attack. And this could also result in action being taken against the insured. by a third party and the losses that they have suffered. So the policy looks to cover the defense costs incurred in any of these actions brought against the insured. And then another subject which is very prevalent at the moment, any company or insured that has a Facebook, Instagram, Twitter presence and are posting regularly on these services, it may result in a defamation or breach of copyright claim or other intellectual property rights interference claims being brought against the insured. And this is the section of the policy to protect the insured against these incidents and claims brought against them, any actions, including their defense costs. So overall, cyber policy insurance is very important and must be considered closely to make sure that all aspects of potential losses are covered by the insured policies. So please keep these in mind when advising your insurers. I'm now going to hand over to my colleague Pierre, and he's going to be discussing the cyber crime section of the crime and civil liability policies and potential overlaps between the two different policies so that you can see which policies best meet your insured's needs.
Hi, good morning. Thank you for joining. So we've walked through generally what the cyber policy intends to cover and the differences between that and computer crime clauses in crime and civil liability policies. So Colin has highlighted many of the salient elements of those, but just as a quick walkthrough of the overlaps between the two policies is in cyber insurance policies, we find that there is cover for cyber crime or that relates to reimbursement of money taken from the insured, so stolen effectively, but through the mechanism of unauthorized alteration of data on the insured's computer system. So in layman's terms, a hack. And there's also, depending on the specific policy in question and the technical definitions, there could also be cover for where funds are taken from the insured through that hack, acting directly on the insured's bank account. And so that is some cover that's generally available, but it's not on all cyber policies, as Colin mentioned earlier. So on computer crime policies, there's in crime and civil liability policies, there's a computer crime clause in many of them that provides cover for direct financial loss. So the difference between the two, as Colin highlighted, is that a cyber policy is geared to react to a cyber incident, whereas crime and civil liability policies generally strive to cover direct financial losses that occur as a result of certain specific risks. And in many of them, these risks are extended to include computer crime. So the definitions get quite technical, but on the direct financial loss element means, depending also on the policy at play, but generally the money that is, or the direct financial impact of an event. So that would mean if there's a hack and money is stolen directly from the insured, it would cover the money that was stolen and not the downstream consequences of the money that was stolen. For instance, fixing the computer system, ensuring that the loss or the threat is stopped, etc. So the computer crime definition and computer virus damage definitions are quite technical, and each policy has their own we'll look at an example here, but and then break down what the summarized version of that is. So going through the computer crime definition, we have a it means typically an unauthorized introduction of electronic data. So in other words, electronic information or electronic instructions, which means just the programs that run on computers. So it's the introduction of data or instructions into the insured's computer system, or if there's an unauthorized modification, corruption, or deletion of the information or the media on which it is stored, then that would trigger this section. Alternatively, if there's an unauthorized introduction, modification, corruption, or deletion of the communication within the computer system itself, that is the first element of this specific definition, but it also requires that there must be a third party that acts dishonestly, fraudulently, or maliciously in doing these things. So it's not like an unintentional introduction of these things is not the intention of this specific definition. So there must be an introduction of some form of electronic data or instructions into the computer system, and which involves dishonest intent. So that is typically, this is a very technical definition of what us as the general public without knowledge of the information technology space would understand as a hack. So if there's a computer hack and that results in a direct financial loss to the insured, money is stolen from the insured, then that is when the computer crime will react to that loss. Then computer virus damage is similarly as a technical definition, and this example, it is the loss or destruction of or amendment to or damage to any information or programs upon which the insured has acted or relied, and due to malicious electronic instructions as run through the insured's computer system. So this is what we would generally understand as a virus. So there's an introduction of a program into the insured system, and it amends or interferes with the communication, and that results in a loss to the insured, a direct loss. Then that is what is intended to be covered by this policy. So the overlap between the two is a reimbursement if money is stolen, or in the case of a computer crime, is a direct financial loss following from a hack or a virus. So going on to the next portion of the overlaps is, other than the direct loss, is extortion. So this means that there's, so under the cyber policies generally, there are covers for if there's a threat by a third party to there's a data breach or malware or denial of service attack or any other sort of cyber incident, and it has an impact on the insured's computer system. If there's a threat of that nature and they require a ransom to be paid to stop the threat or to prevent the threat from occurring, then certain policies will consider reimbursing the ransom payments. But it is important to note that there are legal restrictions on that. It's not always admissible, and there are some legislation that's been proposed to prevent payments of this nature, I think specifically in the United States. And there is a rationale for that, in saying that it encourages the cyber threats to continue, or that it is unethical and it has other downstream impacts. So where it is legally permissible, and of course if it is in line with the agreed strategy with the insurer, the policy will reimburse those ransom payments that is made to resolve the extortion and the threat. So on the that's on the cyber policy side. Then there's historically there's been a clause in crime and civil liability policies to cover direct financial losses following from extortion events. And it's recently, well, not recently, but in recent years been extended to include threats through to electronic breaches, etc. So that is in line with other clauses in crime and civil liability policies that aims to cover direct financial loss, so the immediate financial impact of an event that by reason of a loss of funds or property that is surrendered by the insured as a result of a threat communicated to the insured to either do bodily harm to an employee or to do damage to the premises or property of the insured. And those have been the typical clauses included in this policy, and the extension is to also include the direct financial loss due to surrendering as a result of a threat to damage, destroy, corrupt, or in any other way divulge or alter the programs or information on computers. And so that is the overlap between the two policies. And it is, just to reiterate, that's why it's a good idea to not rely only on a crime and civil liability because it has reference to computer in the policy. It is important to consider that there are other additional covers that is very necessary in the event of a cyber response, as we've seen in the presentation by Lee and Chris, where there's a need for incident response to get an expert out to help and restore the data, notify the regulator and clients, etc. All those other duties that follow that wouldn't be covered in terms of a crime and civil liability policy. And that is in a nutshell the overlaps between the two policies. And I see we have enough time left to consider some questions and answers. So I'll go through what we have. There's quite a few good questions that we'll try to address with the assistance of our experts at Clyde Co. So the first question is, what are the mitigation risk factors that were recommended to each client to prevent the recurrence of certain of those events that was mentioned in the first 3 case studies that Clyde Co went through? Chris or Lee, would you mind answering or engaging in what the outcome was of the risk factors that were recommended?
Thanks, Pierre. I mean, from my side, I think the starting point is to say that every time there is a claims breach, you learn sort of what appropriate mitigation risks are. I mean, that's what makes this environment so challenging, is everyone is actually learning on the job as we go along. And that's why these discussions between insurers and brokers and service providers is so important, because it's such a rapidly evolving environment. 24 months ago, we might not have seen, or we had not seen as many cyber claims as we have now. So it's a really good question. In the context of the claim scenario that I spoke about, just commenting on that specific question, in terms of mitigation factors, what did emerge there, and which I touched upon, was the downstream impact on the subsidiary company. And flowing from that, one of the mitigation factors that we now recommend, particularly when you are dealing with group companies where they acquire new companies as subsidiaries and bring them into the group, the insureds must take steps to properly integrate the subsidiary environment into the group company environment from an IT security perspective. Because as that case study showed, and we've seen breaches globally, and the Marriott breach in the UK, where Marriott was imposed with a very hefty fine under the GDPR. What that claim showed and how it arose was the infiltration through a subsidiary company. In my scenario, it was a target company, then had a knock-on effect to a subsidiary company. But the point remains, from a mitigation perspective, is you do have to ensure that companies integrate and merge their IT security systems when you are dealing with a group of companies. So that's just a brief comment from the claim scenario that I've spoken about. And as I say, the Marriott example in the UK, and if you go and Google it, it makes for very interesting reading. Chris might have a couple of comments from his side as well.
Yeah, Lee, on mitigation measures in relation to the case studies I dealt with, on the Veneer Tech one, we spoke about the importance of multi-factor authentication and looking at the overall security posture of the insured. The focus on the outcome of that incident, once we'd resolved it, was about improving the overall security posture and not only implementing MFA, which probably would have prevented or at least shortened the duration of the incident, but also looking at other improvement measures. So, is there a VPN that should be used? Is there other software that should be used? And often we see post-breach that insurers are often happy to support the deployment of a threat monitoring tool. So similar to that interesting graphic which Colin showed you earlier, which is a live threat monitoring service, threat monitoring tools can be put in place on a particular insured's environment to see if there are any attempts to get back in by hackers or external parties. So that's often an improvement measure that we see and that is recommended by the forensic teams. On the Vulcan Engineering example, it was less important to look at risk improvement measures because, as I said, in that case, that was a rare example where almost everything worked. The nature of the ransomware attack was not through a sort of phishing methodology or an employee clicking on a link. It was a brute force denial of service attack, which can be quite difficult to prevent because as with any kind of crime, if you have a determined attacker, it can be difficult to prevent them getting in, but you need to have the best possible measures in place. It just happened that in that case, the firewall was overwhelmed by a brute force attack. So risk improvement measures would not necessarily have prevented that incident, but fortunately, because Vulcan Engineering was on the ball and had a high degree of preparedness, the incident could be resolved quite quickly.
Yeah, if I could also just mention one thing, because it is such a good question. People on the call might be aware that the Department of Justice itself was the subject of a hack in the last several months. And in fact, somewhat ironically, that incident extended to the Office of the Information Regulator because they fell under the Department of Justice's sort of IT systems. And the Information Regulator had to issue its own notification to the general world at large about the DOJ cyber incident. And they actually had to comply themselves with the reporting obligations under POPIA. And if you, again, it's easy to Google the publication or it can be circulated by us after this call. But it's a very interesting publication to read because in that publication, there is a specific section where the Office of the Information Regulator itself actually speaks about the remedial steps that they are taking from an IT security perspective to improve their IT systems and to safeguard their environment against future attacks. So it's a good publication to read if you would like to get more of a sense in terms of the detail of sort of IT standards that need to be applied to guard against and mitigate the risk of an incident response.
That's very interesting, and I'm glad to hear that we are in fact all equal under the law. So that is a good example. A quick one, and I think this is good for the legal team. What is the role of a data protection officer, and is it advisable for an insured to outsource this function?
Yeah,
Perhaps
thanks.
I can have a bash at that, Lee.
Yeah, go for it, Chris.
So a data protection officer, if I understand the question correctly, is probably a reference to an information officer in terms of Pierre. As I understand the Act, it is not permissible for a company to outsource that function. So the default position under the Act, if an individual is not nominated, is that the chief executive officer of a company is the information officer by default. Many of you may be aware that there was a registration exercise which went through the course of last year with the information regulator, and a company, it is advisable in our view to nominate an information officer who's not the CEO, but who is familiar with the IT environment, and preferably one or more deputy information officers who can assist in the discharge of that role, because the responsibilities are quite broad. So unlike many other aspects of company compliance, it's not something that can be outsourced. It must be somebody from within the organization, and preferably somebody who naturally operates in those areas of responsibility.
Mm-hmm. I suppose if the appointed information officer is uncertain, they can contact external providers to guide them on their responsibilities and assist them in fulfilling those roles.
Absolutely, Pierre, yeah. So if they need legal advice, or if they need advice from other specialists, they're welcome to take it, but they are the day-to-day person who's responsible.
Oh, good. Another question arising from your case studies are there any costs incurred with the live simulations or the drills? And other than related to that, is there any legal consequences arising from those scenarios?
Yeah, again, I'm happy to address that. The answer is in some way it depends. Some of our insurer clients are happy to pay for those scenarios or for the meet the breach coach sessions that we spoke about, which are often just introductory in nature. If we're looking at more of a simulation or a fire drill type exercise, there would be charges associated with that. We typically offer that on a package pricing basis, and the pricing will be agreed in conjunction with other service providers who were involved. So there may be the digital forensic team which runs the scenario, and there may also be, for example, a PR firm which will simulate the communications response to an incident. But we believe it's best that those are done just on a package pricing basis. So it's priced similarly to how it would be for a real incident, but of course with greater certainty in how it unfolds. If there is interest in undertaking those exercises, I would suggest speak to the insurers in the first instance, and they can then, if necessary, make contact with us to arrange that.
Sure. Yeah, or the relevant incident response provider.
Correct. Thanks, Pierre.
I guess it's still early days, but have you seen any examples of insurable fines and penalties under POPIA regulation specifically?
Pierre, let me jump in there. It's a very difficult question to answer because generally speaking, as I understand, under our law, there's very little, or in fact no authority in terms of the question of insurability of fines and penalties. What we do know as a general principle is that if that issue came before our courts, it would be a question of public policy, and our courts would have to weigh up whether it would be against public policy to allow for the insurability of the specific fine or penalty. Now, we do know that some fines and penalties imposed by legislation are punitive in nature or are penal in nature, or have the statutory intention to criminalize behavior. And as a general principle, those types of fines and penalties would not, as we understand, be insurable under the law of South Africa. it might be the case, depending upon the specific act and the wording, that the fines or penalties are designed to be compensatory in nature, and perhaps our courts would take a different view and would deem those sorts of fines and penalties to be insurable. So it's not a question that we can answer with any certainty. It's a good question in the context of the fines imposed by Pierre. It's one of those matters that is not settled law, and we will have to wait and see what happens ultimately if and when that point is tested in our courts. And of course, each instance would be determined by the specific facts and merits of the matter, the act itself, and the statutory intention of the fines and penalties. So I've given a typical lawyer's answer, but that is just the position as we understand it.
Yeah, no, I hear you, typical lawyer answer, but we've had the same difficulties. So no, that is a very thorough answer. Thank you for that, Lee. Then the next question that I'd like to address is the question around ransom payment. So maybe you have some examples or tips to add, but the question generally is, what security do you have if you pay ransom that the data won't be leaked to the media, or the data that's been encrypted will be released? So from my understanding is in those instances, the forensic experts do sort of an analysis to see what the background is and try and identify who the threat actors are. And then if they are known, and you make it known to them that you know who they are, then generally there's a risk for them that there's a name and shame, so that others, if they find out that ransom was paid and they didn't act according to the agreement, that the next person won't pay the ransom. So that's one of the things I've heard. Is there anything from your area, that some assurance that the client might have if the ransom is paid, that they will obtain the results that they intend?
Yeah, Pierre, I'll tackle that. The byline with ransom, when you're considering payment or negotiation, is very much in capital letters: proceed with caution. It is a sensitive and delicate decision. There are no guarantees, and what we encourage clients to consider is that they must always remember, if they wish to enter into a ransom negotiation, that they are dealing with criminals. And like any criminals, the point of departure is that they should not be trusted. That said, there may be situations where it's advisable to consider paying ransom, or where the business impact is so severe that the payment of ransom will bring an end to the horror of an incident. And we have been involved in matters where ransom has been paid. So we are able to guide clients on issues around legality of paying ransom, method of paying ransom, which is typically in cryptocurrency, and how that can happen. What are the risks in terms of, if you pay, that there will be a further extortion attempt, or that they will just come back in 12 months' time and hit you again? There is a higher probability that that will happen. And then the kind of thing that we're seeing with TransUnion, where if you refuse to pay ransom, as TransUnion has, will the hackers try and escalate it by other means? As we've seen here, where they go to TransUnion's clients, and where they've gone to selected journalists to up the ante and create public pressure. Each incident has its own unique features, and fortunately there are specialist ransom negotiators and cyber ransom consultancies which are able to help with this, and we do work with them on incidents. So there's a lot to think about. We always encourage clients firstly to think about what is their position in principle, and then what is their position relative to the actual impact on the business. Can they tolerate a few days of disruption, or are there other factors that make the payment of ransom necessary?
Thank you. That is a comprehensive answer. Thank you very much, Chris. I see that brings us to the end of our allotted time. If I could ask all participants to quickly click through to the link in the chat box to complete the survey on our event. And then it remains for me to thank everyone for joining and our experts for speaking. And there's one question that I see that we have not been able to answer that's recurred, and that is relating to the email scams. And perhaps that is a good topic to expand on in a future claims close-up involving some of our other teams that ensure the professional side of things, and they also have extensive experience on this. So you may look forward to potential future presentations in that regard. Thank you, everyone, for joining us.
Thank you, Pierre. Thank you, everyone. Have a good day.
Thanks, everyone.